So the name of this seminar is You Can't Take It With You. And the reason that I start out that way is because you'd be surprised how many people think they're never going to go, or if they do, they can take it with them. And it's, it's a topic that makes people nervous. So just so you won't be nervous, I'm going to tell you a little joke about dying, okay? So there's this fellow, and he's out playing golf, and lightning strikes him. And he opens his eyes, and he's at the pearly gates. And there's St. Peter. And he says to St. Peter, "Hey, I'm not ready yet. I can't come here yet. I've got things to do." And St. Peter said, "It's your time." He goes, "Give me 24 hours, just 24 hours, okay? I'll be back in 24 hours. So St. Peter says, "Well, why?" He said, "Well, there's just some things I have to do before I come in." So St. Peter goes, "Okay, you got 24 hours, but you'll be back here in 24 hours. So 24 hours later, Mr. Golfer comes, and he's dragging this big suitcase with him. And he comes up to the pearly gates, and he goes, "Okay, St. Peter, I'm ready now." And St. Peter goes, "What's in the suitcase?" He goes, "Well, this is why I had to go back. I just needed to pack up." And St. Peter goes, "People don't take suitcases to heaven. What's in the suitcase? Just open it, show me." So the golfer opens the suitcase, and it's full of gold bars. And St. Peter says, "Pavement? You brought pavement to heaven?" That's my joke. Okay. So the point is, if you can't take it with you, what's going to happen to it when you go? Okay, so that's what we're going to talk about. So when you go to see an estate planning attorney, they'll do a package for you, because there's a whole series of things that you need in order to make sure that you're prepared when it is your time to go. You need a trust, which we're going to talk about. You need a will. If you need your own will, and then your partner or your spouse needs a will as well. You need a power of attorney that designates someone to act on your behalf with regard to your business interests. You need an advanced health care directive, and that's for someone to act on your behalf for your health care issues and to decide where you're going to live if you can't decide that for yourself. Are you going to be in your home? Are you going to be in a nursing home? Are you going to be in some other kind of facility? You need a nomination of conservator. This is if you're unable to act for yourself, who would you want the court to appoint to act for you with regard to both your body and your estate, your funds? And if you don't name somebody, what the court will do is the court will appoint somebody from a list. And they won't know you, and you won't know them. And if you have to be conserved, you don't have what's called legal capacity. So at the point you have to be conserved, you can't say to the judge, "Hey, I want my sister to do it for me," because you don't have legal capacity to say that at that time. So you have to take care of this stuff before you need it, because once you need it, it's too late. So there's a misunderstanding with people about what requires probate and what doesn't require probate. So if you have assets when you die that amount to over $150,000, if those assets are not in a trust or not in a paid-on-death account or not in a community property or joint tenancy account, then those assets will have to be probated. So what's the difference between probate and just administering a trust? Well, when you have a trust, it's a private thing. It's your trustee and it's the beneficiaries, but it's not in court. It doesn't get published in a newspaper. Everybody in the world doesn't get notice of it. It's not filed with the court. And because it's not filed with the court, it's not discoverable by anybody unless they're a beneficiary or a trustee and they're entitled to know what's in there. If you have to probate a matter, it has to go to court. You have to file the will with the court. You have to file what's called an inventory and an appraisal. So everything you own gets described, valued, and filed with the court. And there are people who can go on the court website and they can look at those documents. Anything you put in your will, if you decide that you love cats and you want to leave everything to your cats, the whole world's going to know about it if it has to be probated. If you want to cut some family member out, the whole world's going to know about that because your will's going to be filed with the court if you have to go to probate. The other distinction is the cost involved. So to do all of these things, when you visit your attorney, it varies from attorney to attorney. Different attorneys have different attorneys' fees, right? But generally speaking, if you come to me, it's sort of I have a home and I have some bank accounts and maybe I have some mutual funds or something. It's going to run between $3,500 and $4,000 to get the whole thing done, put all of your assets into the trust, and do all of these other documents for you and get them all signed and notarized and recorded and what you need to do. If your estate has to go through probate, there's a set of fees that the state has determined is what they're going to charge for probate fees. And it's called statutory because it's set in that statute. And it's percentages. So it's 4% of the first 100,000, 3% of the next 100,000, 2% of the next up to 800,000, and then 1% of $1 million to 10 million over and above that first million. So you can do the math in your head. If you have one of these houses that Jean was just talking about that's worth $1.5 million, then it's going to cost in attorney's fees better than $25,000, just the statutory fees. Then besides that, you have all of the filing fees with the court. And these days, courts are all moving to electronic filing, so you have to use their third-party company that will do the electronic filing, and they charge you by the page, okay? So it gets to be an expensive proposition. If instead your assets are in the trust and your trustee calls me up and says, hey, I see you did my mom's trust and she's passed away now what do I do? Well, you come see me and I will give you your to-do list after I review mom's trust, and then I'll walk you through what needs to be done. And depending upon how complicated it is, that's probably going to run another $4,000 to $5,000 instead of $25,000. So it's much more cost effective to do a trust. And again, what's in the trust is between you and the beneficiaries and the trustee. That way it's not filed in court, and you don't have everybody in the world taking a look at it if they feel like it, okay? So those are a couple of the issues. So you have this, which is a copy of my card, in your little packet, but some of you also have a card, so you know how to get a hold of me if you want to. So a couple of things I wanted to tell you first before we get too far into it. First of all, you see back here that there's somebody who's doing a video of what's going on here, okay? And Jean is going to put this up on YouTube. So just keep that in mind. If you ask a question, it's going to be on YouTube, okay? And I mention that because I want to let you all know that I'm giving you general advice. I'm not giving you advice specific to you because you probably don't want the whole world to know your business, first of all. And secondly, I can't, it's kind of like going to a doctor and saying, hey doctor, I have a headache, what's wrong, do something. I won't know exactly what you need until I talk to you, look at your whole situation, and sometimes situations are complicated. And so if you ask me, you're welcome to ask me questions when I'm all done today, but just keep in mind that without seeing your whole situation, I can't really give you a good answer, other than to tell you, come in to the office, we'll sit down, and we'll talk about your situation. And before you do that, what I do is I will send you a list of questions for you and your partner to sit down together and talk through and answer before you ever come in to see me. And the reason I do that is, first of all, it saves you a lot of money if you're not sitting there in front of me going, well, no, I don't want to give Uncle Fred everything. And your spouse or your partner going, well, I do. So what do you do? So I want you to come see me prepared, and have worked those things out if you can before you come see me. Because part of what you have to do is not just answer the obvious question. So most people, the obvious question is, who are you going to leave it to? And for most people, they kind of have an idea in their mind. If they have children, they probably want it for their children. But they might want it for the Humane Society or something. You can do that, it's your stuff. But you need to think about what happens if that person or agency or charity no longer exists when you pass. So what happens then? Who should be the person or the place that gets your stuff if that first choice of yours isn't around? So it's those kinds of things you want to think about. And the reason you want to think about them is because life changes. And we don't have a crystal ball. We don't know what's going to happen. But we need to try to plan for contingencies, right? So what happens to taxes? So a lot of people do their estate planning just because they want to say who gets it next. But a lot of people do their estate planning because they're concerned about their taxes and they want to minimize their taxes. So yes, you have to pay the taxes that you have to pay, but there are ways to minimize the taxes you have to pay if you do some good planning. So the Congress keeps messing with both the tax rate and what the limit is under which there's no tax for estates, okay? And we don't know when you're going to go, so we don't really know what the law is going to be when you go. But what we do know right now is that if you were to go this year, there would be an exemption of $11,400,000 without having to pay estate tax. So what if you had less than $11,400,000? Maybe you've got $5 million in assets. So and your spouse dies. So what happens to your spouse's leftover exemption? Because maybe you've got better genes or you take better care of yourself and you're going to live another 15, 20 years and your assets are going to go up in value. Well, if you file what's called a Form 706, you can make an election to the IRS, even if there's no tax due, to tell the IRS that you want to carry over the unused portion of your spouse's exemption. But you have to make that exemption in the year they die, and you have to make that exemption within 6 months of their death. So that's, again, something that you want to keep in mind as a way of diminishing your estate tax that may be due later. Because then, if your spouse had only $5 million in assets, then he hasn't used $6,400,000 of his exemption. You have $11,400,000 of exemption. You can carry over his $6,400,000 and add it to your $11,400,000, but only if you file the form. If you don't file the form, you're out of luck. You can't go back and do it. So again, that's something to keep in mind. Now, one of the things that a lot of people did in their trusts, and this is one of the reasons you may want to take another look at your trust if you have it, they would set up the trust back in, say, 2011, when the exemption was $5 million. And what they would do is they would set it up so that if the first spouse to die, there would be a separation of the trust assets. And there would be 3 trusts set up when the first spouse died. One would be the survivor's trust. And in the survivor's trust would be half of the community property of the couple and the separate property of the survivor. And then there would be a separate trust set up called a bypass trust, or a B trust, sometimes they called it. And in it would go the separate property of the deceased spouse and their half interest of the community property. And then there might also be what's called a marital trust. At one point in time, there was a limit between what a husband and a wife could pass to each other without incurring estate or gift tax. And the feds did away with that limit. So right now, spouses can pass whatever they want to each other, and it's not taxable. But that might change. So what happened with a lot of trusts in the past, they set up this complicated system of separate trusts. So once you do that, and you have to get a new tax ID number for the bypass trust, because guess what? You don't own that stuff anymore. You get the right to use the income from it for your life, but it's owned by whoever the eventual beneficiaries are. And the reason for doing that was so that those assets wouldn't be counted twice when the limit was so low. They wouldn't be counted as in the estate of the deceased person and then counted again when they went to the surviving spouse when the surviving spouse died. Well, with the $11,400,000 exemption now, a lot of people are saying, why do I have to go to all that trouble, A? B, I don't really like the idea that my kids really own half of my stuff. And I just get the income from it, and I'd rather not do that. Plus, when you have a separate tax ID number, guess what? You need a separate tax return for that trust. So that's more money, more complications. Now, do some people still want this bypass trust? Well, sometimes it makes sense. So it might make sense if, for instance, there's a second marriage and the survivor wants the kids from the first marriage get the stuff and the kids from the second marriage not to get the stuff. Then it makes sense to have a bypass trust, because what happens is that bypass trust becomes irrevocable when it's funded, so it can't be changed. So that's the way to make sure that those kids from the first marriage get the stuff, because it's in the irrevocable trust. So sometimes it makes sense, but a lot of times it doesn't make sense. And it's one of those things you probably want to look at to see if your trust calls for having all of these separate trusts and doesn't make sense in your circumstances. It may not. So what happens if you don't have a will or a trust and you die? What are your spouse's rights? So community property is owned by the community, right? It's owned by husband and wife. So half of it already belongs to the survivor if it's a married couple. But what happens to the other half? So if it's community property, the other half goes to the spouse that survives. And there's no need for probate for community property because it automatically goes to the survivor. If it's separate property, so what is separate property? Separate property is stuff that you had before you got married, and it's stuff that you inherit while you're married. So if your parents died and left you in an apartment building in the city, that's your separate property. And the only way it becomes community property is if you sign something called a transmutation agreement and you say, I am making this community property. It used to be in the old days, it was if you commingled it, then it suddenly became community property. That doesn't happen anymore, that changed. So it's your separate property. What happens to your separate property with regard to your spouse? So if there's no will, you have to probate it and tell the court there's no will. And what does that mean? That means nobody's named as executor. Nobody can handle that estate until the court appoints somebody. How do you get the court to appoint somebody? Well, you have to give notice to everybody who might be an heir, any relation, and then go to court and get appointed. So what happens to the stuff? Well, it will go to the surviving spouse if there's nobody else, okay? If there's a surviving child or a surviving grandchild, half of it goes to the spouse and half of it goes to the child or the grandchild, or it may go to the parents of the deceased spouse. Or if they're not alive, it may go to the siblings of the deceased spouse. And you know, I luckily have a really great relationship with my brothers and sisters, but I have to tell you, in 30 years of practicing law, I found that to be rare, that there are a lot of families where really the surviving spouse would not want to, for instance, co-own a building with one of their in-laws. And that'll happen unless you take care of the documentation. And it would be 1/3 where there's more than one child or more than one grandchild. It could be split between, so say you had 2 children and one had predeceased you, but they had children. So it could end up belonging to a grandchild in one case and a child in another case, but they'd have to co-own it. And if that child was under the age of 18, somebody would have to be appointed to represent them, who is an adult, because they can't do anything under the age of 18. They don't have legal capacity. So there are all sorts of horror stories I could tell you about this. I have to be careful, though, because I don't want to disclose any personal information of any clients. But I had a case where the surviving spouse, a sister showed up and said, oh, I'm going to invalidate this trust in this will. I'm going to challenge it because my brother loved me more than he loved his wife. And you know, we had to go to court, and this couple had been married for 10 years. We had to prove that, no, in fact, the husband was in his right mind when he named his wife as his beneficiary in his trust and when he put all of his assets into the trust. Now, when did he do that? I got the phone call from the hospice nurse on Friday, ran down to his house on Friday. He signed on Friday. He died on Monday. So, you know what? We got it done. But it was something of a nightmare for my client. So, another for instance, my aunt, okay? I loved my aunt dearly. I met with my aunt several times. We sat down. I brought my laptop. We wrote up a trust for her. And she kept saying, no, I'm not ready to sign it. No, I'm not ready to sign it. No, I'm not ready to sign it. And it was my aunt, so I didn't push her, right? Then she had a stroke. She couldn't sign it. She lost capacity. She did not have legal capacity to understand what she was doing after she had her stroke. So now we're probating her 1991 will. And luckily, we had a copy of it. And amazingly enough, I found one of the witnesses who had witnessed the will, and I had to take him to court. Luckily, I got a declaration from him, so he didn't have to actually show up in court, and prove to the judge that this was, in fact, the operative will. And I had to get another declaration from the executor named in this copy of the will, that, in fact, my aunt had sat down with her and said, this is my will, this is the way I want it to go. Because otherwise, there's a presumption of the law that if you don't have the original of the will to take to court, that the deceased person has torn up the original and doesn't want that will. So you have to overcome that presumption when you go to court. So I've been probating my aunt's will because she's a family member and because the estate was very small. I'm only going to ask for the statutory fee, which is also very small because remember it's based on a percentage, right? But if I were charging my regular rates, keeping track of my time, I've already invested $30,000 worth of my time in trying to get this thing probated, and we're still not done. So, and again, luckily I'm dealing with a bunch of heirs who all like each other, and they're all being cooperative, and they're signing the paperwork. If I had to fight with people, it would really be a nightmare. And there are an awful lot of times when there are fights about where does the stuff go, you know? Even when there's a provision in the will or the trust that says, if anyone challenges this, they get only $1 or they get nothing, well, guess what? The court will not uphold that anymore because the legislature decided that if people want to fight about a will or a trust, they ought to be able to do that. And so the legislature in their wisdom said, we're not going to pay any attention to those provisions in a will or a trust that says you don't get anything if you fight about it. Do we still put them in the will and the trust? Yes, we do. Why do we do that? Because the legislature changes their mind all the time. And so we want to make sure you're covered in case they change their mind. But as of right now, the state of the law is, if you put that in your will or your trust, it can still be challenged. And unfortunately, there are some unscrupulous attorneys out there who will take a case, even if the client doesn't have a case, because they figure they'll get paid off something to get rid of them, right? And it's unfortunate, but it happens. So what you want to make sure you have is a well-written trust, a provision in your will that's called a pour-over provision that says, if I forgot to get something into my trust on my death, it goes in my trust. Now, does that mean it automatically goes in your trust? It should, but it doesn't. If you want clear title, then you have to go to court and you have to do what's called a Hegstad petition. Hegstad was a case where it was decided that if somebody put a provision in their will that said, if I miss anything and don't put it in my trust, I want it to go into my trust, that they really meant that. So the court had to decide that, in fact, that's what was meant, and it was Mr. Hegstad, and it was his estate, and so it's called a Hegstad petition. What does it cost to do that? It costs about $2,500 in legal fees to do that, okay? So make sure that when you say your stuff is in your trust, it's actually in your trust. So putting it in the document doesn't put it in the trust. In the case of a house, you have to actually do a deed to transfer it from you to you as trustee of your trust. If you have a bank account if you have a stock account, mutual fund account, a trading account, any other thing, if you have expensive art, you have to actually make sure that whatever registration there is, it's vested in you as trustee of your trust. So another document that we do is we do a trust certification. And under California law, all of these institutions must recognize the trust certification. And the trust certification in it says, this is the name of our trust, this is the people who wrote it up, these are the people who are presently the trustees, this is their address, this is the way we want these accounts vested. So put it exactly this language. So does that do it still? No, you still have to then sign the paperwork from the institution in order to make sure it's in the trust. So what happens when that doesn't happen? Well, I've got a case right now. Some apartment buildings that were in the trust, some bank accounts that were not. So we had to go to court. We had the choice of either doing a Hagstad petition or doing a probate. These clients chose to do a probate, so they're doing a probate for 2 bank accounts, okay? Everything else was in the trust, but we had to go and do all of the paperwork for 2 bank accounts in order to get them access to the bank accounts. Why? Because the bank accounts were not vested in the name of the deceased as the trustee of their trust. So they weren't in the trust. We could have done a Hagstad petition, they chose to do a probate instead. So I'm back in court doing another probate.
Shareholder questions, or can I ask?
Go ahead.
Okay, I got 2 questions. So what about joint tenancy title?
So a joint tenancy title does not have to go through probate. There are some issues with a joint tenancy probate. With a joint tenancy titling. So even though it doesn't have to go through probate, when someone, there's a complicated process for whether or not you can get around the property being reassessed if you are selling that half interest or even just transferring that half interest. It's possible to do, but you have to take a couple of steps to do it. The other thing with a joint tenancy, it's a little bit complicated because you have to have acquired the property all at the same time and acquired all of your interest at the same time. So I have a case right now. 2 daughters and mom bought a property in joint tenancy. 2 daughters were advised by their estate planning attorney, badly. Their estate planning attorney said, you should put your share in your trust. So they did. Well, what happened is that broke the joint tenancy. So mom dies, there's no more joint tenancy. So now we have to probate that asset because by putting it in their respective trusts, they broke the joint tenancy. So joint tenancy is tricky, and it can be destroyed very easily. And that's only one of the reasons why we advise people not to do a joint tenancy, because there are other better ways of handling your property.
So if it's not in trust, how does that share, what happens to that share?
The one I was just talking about?
Yeah.
So that 1/3 interest would have to be probated. So instead of the sisters each inheriting half of mom's interest, which was what they intended, now they have to probate it. So otherwise, they can't get title insurance to that property, okay? So now they want to sell that property, and guess what? There's an uncooperative brother who's going, pay me. I'll sign off if you pay me. And he was never intended to get any piece of it, okay?
Right.
So again, it can be very tricky. The other thing is that for tax purposes, when you own property together as community property, when you own property in trust, what the state of the law is right now is the property gets what's called a step up in basis to the date of death. And so if you then sell it, there's a very small capital gain if you sell it within a short period of time. And it's very important to get a realtor or someone else to appraise the property so that you have that appraised value as of date of death. And a lot of people, I bought my house in 1978. And I paid $134,000 for it. And my house now, I don't know what you think it's worth. You tell me what you think it's worth. It's 3,700 square feet. It's got a 180-degree view of the bay. And it's in Millbrae. So what do you think it's worth, right? I can't, my husband and I, we can't afford to sell it until one of us dies, frankly. And is it in the trust? Yes. But, if we had to pay the capital gains tax on our basis in that, now, have we done a lot of stuff to it? Yeah, we have. We've added on and remodeled, and, all of that adds to your basis. But, right now, I may have a house worth $2.5 million, but I would be given half of that to the government, basically. When you own the property in trust or you own it in community property, the whole thing gets a step up in basis on date of death. If you own it in joint tenancy, what's the difference? Well, joint tenancy means you only own half and the deceased person only owns half. So what gets a step up in basis? Half, not the whole thing. So that's another reason not to put it in joint tenancy. Okay?
And then the same question goes back to your aunt, the example you gave about your aunt. And you mentioned that it's still, if you had higher attorneys, still would cost $30,000 for a very smooth probate. Is that like a minimum for any probate?
No. In this case, it's there were complications. Okay, so one of the complications is there's a whole bunch of heirs because my aunt was one of 9 children, and all but one of those have died now. But guess what? They had children, and so it's just a matter of, even though everybody's being very cooperative, it's I sent out some paperwork to the 7 children of one of the deceased siblings, and for a waiver of the accounting so that we don't have to pay an accountant to put together an accounting. And so I'm getting them back and I'm looking at them, and this one hasn't put in the date, and that one hasn't put in the place where they signed it. And this one left out, their middle initial. And so I just have to keep calling them up going, hey, can you do this? Hey, can you do this? Hey, can you send me this? And they're all being cooperative. It's just, a lot of people trying to herd cats, basically. But an attorney can apply to the court for more than the statutory amount if there are complications, and oftentimes attorneys will, because oftentimes there are complications. Okay? All right. So why update your trust? Well, we mentioned the idea of bypass trust. Does your trust contain a bypass provision that you don't need anymore? Do you want to carry over your spouse's share of the exemption after their death? Or do you want to just pass stuff to your grandchildren? There may be reasons. Unfortunately, there are families where, one of the kids has a drug problem, or one of the kids has a huge judgment against him that if he gets something, it's going to go to the guy who got hit by a car when your kid was driving. You might have a child who's got special needs, and he's got a special needs trust. And I was talking to people about this the other day too, and the wife said, well, if I go, I want my assets to go to my brother. I said, you mean your brother with the special needs trust? And she said, yes. And I said, well, do you know what happens with that is that because they're receiving state assistance, when they die, the state comes in and collects all of the money they've paid out of whatever assets are left. So does it make sense to leave stuff to somebody if it's all going to go to the state? Or maybe you want to think about who you want to take care of your brother with the special needs trust. Have it go to them and tell them it's for taking care of your brother who has the special needs trust. Maybe that's a better way to arrange that. And she said, that's not fair. And the government would take it. And I said, well, you know, if you think about it, the reason they do that is so that they have a pot of money for the next guy who needs a special needs trust, because otherwise it's not sustainable. So, you know, those are the kinds of considerations that you have to think about. Is there a change in your family? Do you have new grandchildren? I have a grandchild that has come along since my husband and I did our trust, so we actually redid our trust to make sure that we accommodated that we want our grandchild taken care of. Not that we don't think our kid will, but we want to make a direct gift to our grandchild. One of the ways we did that is we set up an education fund for him. And there are special education funds you can set up for a grandchild that are beneficial tax-wise, called a 529 account. And the growth on that account is not taxable to you, and it's not taxable to them until they start pulling the funds from that account. And if they're in college when they're doing that, guess what? They're probably making minimum wage, and their tax rate's going to be very low. So it's another good way to plan for passing your assets in a way that will do a lot of good, and also that will minimize your taxes. So, do you have a new house? Have you inherited a piece of property? Maybe mom and dad passed away and you ended up with their house or their apartment building or something. How is that title? You know, you want to make sure. So we talked about separate property, community property. One of the things that we do in the trust is we say, I can put anything I want to in my trust, and if it's separate property, it will keep its character as separate property, even though it's titled in the trust. If it's community property, it will keep its status as community property, even though it's in the trust. And that way you don't need a trust for community property and another trust for separate property. Do some people want to do that? Yes, some people do, and we'll accommodate that. But for most people, it makes sense just to do it all in one trust and just write it the way that accommodates their situation. So one of the things that you want to make sure you do is, again, I can't stress this strongly enough, make sure that your assets are properly vested in your trust. Now, maybe you have some charitable interests, or maybe you put charitable interests, bequests in your trust, and the situation has changed. I had one woman that she wanted a charitable bequest to a certain animal shelter. Well, that animal shelter has closed down now. Had another one, and she felt very strongly about a certain charity, and then she found out that the general manager of that charity is walking away with $30 million a year as their salary. And so she wanted to change that when she found out about that. The time to do it is while you're thinking about it, get it done, okay? Because guess what? If God forbid something happens to you, it's too late to do it then, okay?
In the case where the state can go into a trust and withdraw, you were talking about that?
Yes, a special needs trust.
Is that, are you talking about SSI or SDI?
Yes.
Yeah.
Yes.
Can you repeat the question for them?
Yes, so where I mentioned that the state can come in and make a claim against the estate of someone who's been receiving benefits, it's where you've been receiving special benefits like SSI, okay? And for that, I mean, you can set up there are special rules for setting up special needs trusts. But for your special needs trust to pass muster with the state, so that you're not disqualified on the basis of what's in your trust, then you have to have this provision in the trust that allows the state to come back and get basically compensation back for whatever they've put in. And you have to give them notification after death. You don't have to if you're the one gone, but whoever's handling it has to give them notification, and they have 90 days to file their claim. Okay. So the same questions go for if you have a healthcare directive. When was the last time you looked at it, and what does it say? Okay, who is it who's going to act for you? Is that still who you want to act for you? Do they still have the same phone number? Do they still have the same address? Because how is somebody going to get a hold of them if they've moved, if you haven't updated that? Do you still have the same doctor? In the Advanced Health Care Directive, this is where you say, I do want to be kept alive as long as medically possible, or I don't if I'm in a coma and I have a disease that's likely to lead to my death in a relatively short period of time. So there are a lot of people who, when you're healthy, you think, oh, I don't want to be a vegetable, and I think I'll mark that I do not want to be kept alive. And then as they get older and they see what happens sometimes, they decide they want to change that, and they want to be kept alive as long as a doctor says that it's medically reasonable to do that. I have another story about that. My mother had developed dementia. Before she did, we sat down and we did the trust and all of these documents. And my mother named my sister to be the one who would make decisions. But my mother, after a lot of thought, said she wanted to be kept alive. And so 20 years later, she's developed dementia, and she stops eating because she's forgotten how to swallow. And unfortunately, this happens a lot with people who have dementia. They forget how to swallow. She had a bladder infection. We didn't realize she was in a care facility. We thought she was losing weight, but we didn't realize it was because she wasn't eating. She went to the hospital for the bladder infection, and the doctor said to us, well, just let her go. She's got dementia, just let her go. And we said, but she has dementia, but she doesn't have cancer. She doesn't have a heart condition. She's got a couple of years left in her, and we'd like her to enjoy them. And he goes, she's going to go anyway. You're not going to change the outcome. And I went, doctor, we're all going to go, but we might have some time between here and then when we could enjoy some life, And he said, well, I'm not going to authorize a feeding tube because then you're going to have to make a decision whether or not it comes out. And I said, I pulled the old attorney card. I said, doctor, I'm not only her daughter, I'm her attorney. And I'm telling you that she wants to be kept alive as long as medically possible. And she thought about it a long time before she signed that. And so that's what we're going to do. So if you can't authorize a feeding tube, I want a doctor who will. And he said, okay, I'll send you somebody else. He left. I got another doctor. The doctor came in. He was Vietnamese heritage. And we explained what we wanted. And we said, we don't want extraordinary measures taken. Her bones are like powder, so we don't want somebody to pound on her chest if her heart stops because her ribs will just dissolve. But we want her to have her diabetes medication. We want her to have her blood pressure medication because that'll keep her comfortable. We don't want her to be uncomfortable. We want her to have a feeding tube, and then we want somebody to teach her how to swallow again so that she can do that. And the doctor said, you know, that kind of palliative care is what we do in Vietnam, where we care about our elders, and they're not somebody to just throw away when they're no good anymore. And so he was an excellent doctor. She lived another 4 years. Yes, she learned to swallow again. Yes, they took the feeding tube out. She got to meet her great-grandchildren. And you know, yes, she had dementia, but when any one of us walked in the room, her face lit up. She might not know which of her kids it was, but she knew it was somebody who loved her. And she got some more years of life. Why? And I go back to that. We had a doctor, and we were ombuds people for our mom to make sure she had what she wanted. So I go back to think about it very carefully. What is it you want if you can't make that decision for yourself? Because you want to tell the person who has the right to make that decision for you, that you've named, specifically what you want. And you don't have to follow the form. I mean, there's a space to write in on the form. I had somebody in the other day. She said, I want to be given a fighting chance. I said, write that in. And she did. So keep in mind, these are important decisions. They're hard decisions, but they're decisions that you should make, because if you don't, it's going to be so hard for the person who has to make the decision for you to make that decision if they don't know what it is you wanted, okay? Power of attorney. Most people will name their spouse to file a tax return, to write a check on their account, to sell the house, to file for health insurance benefits, all of those kinds of business things. But what happens if your spouse is not available or not able to make those decisions? You can name a backup person. So who do you want to name as a backup person? You want to name somebody you really trust, because they could sell your house, they can write your checks, they can claim your insurance, all of those important things in your life. So there's something called a springing power of attorney, and what it says is this power of attorney is only effective for my son to act on my behalf if I am incapacitated and he has a letter from a doctor saying so. And that's what I generally tell people for the backup person. Make sure it's a springing power of attorney, because you probably don't want to put that on somebody that like one of your kids or a friend or somebody, unless you really need it because you're incapacitated. So again, in your will. So what's the difference between a trust and a will? So a trust is usually the big stuff, the over $150,000 stuff. And a will is usually the specific bequests. You know, I want my engagement ring to go to my daughter. I want my classic car to go to my grandson. It's those kinds of things. It's who do you want your personal possessions to go to? And the executor, the person that you name as executor, is going to be the one who can tell the hospital where to take your body once you're gone, who can sign for your funeral. They're going to be the one who's going to clean out your house. They're going to be the one who's going to do the kind of personal stuff for you after you're gone. So one of the things that I tell people is make sure it's somebody you trust, somebody who understands you and what you want. Sit down and talk to them before you name them and make sure they're okay with that. One of the reasons for doing that is because if you name them and they don't want to do it, then somebody has to go to court and get appointed to do it. And in the meantime, nobody has authority to do anything with your remains, okay? So make sure somebody's going to be named who wants to do it, okay? Name a backup in case that person's not around anymore and they predecease you. The other thing I tell people to put in their will is, what do they specifically want to have happen? Do they want to be cremated, or they don't want to be cremated? Do they want specific services? Do they want a big party? Do they want to? I had one fellow who came to see me, and he wanted specific verses of Amazing Grace sung at his funeral. And so what we did is we typed that up and we attached it to his will so that when the time came, somebody knew exactly what he wanted. We ask people to tell us, because I'm not going to make it up. It's you who are going to decide what you want. But we want to put that in your will. What's the reason? The reason is if you're gone, how's anybody going to know, right? It's a very hard thing for your kid to find out that you've passed and they don't have a clue what it is you wanted. And sometimes that leads to big fights in families. I have a case right now where brother and sister did separate services for their mother because they couldn't agree on what it should be, okay? If you don't want that, be real clear. I have another client, and she brought her son and her daughter, and she brought a list of everything she owned, all her dishes and glasses and her knickknacks, and they each picked. Okay, your turn. Okay, your turn. Okay, your turn. And so we have an attachment to her will, and it says, this set of glasses goes to daughter, this set of plates goes to son, and they worked it all out. And she did that because she didn't want them to argue about it afterwards. Do they actually want those glasses and dishes? They may not. But, they figured, okay, if mom wants it, we'll do it, right? So these are some of the things that you want to think about, that you want to consider before you go to see an attorney. And you want to make sure that those things are in your documents. It's very important. You put it in writing. It's an uncomfortable conversation to have, but sit down with your family and explain things to them. Another thing that I do is I tell people, if you're not going to divvy everything up evenly among your children, let's put in your trust why. Because otherwise they're going to fight about it, okay? They might be unhappy about it, but if they understand why you did that, first of all, they can accept it better. Secondly, if it goes to court, what's going to be important in court is what was the intention of the person who wrote this. And if you have it there in your trust, it's going to be kind of, bulletproof, right? So it's important to tell your children what's what. It's a difficult conversation to have, but once you do, you're gonna make things. It's a big gift to your children for after you die, that they will understand what you want to do. And you know what? We don't have what's called primogeniture here in the United States. They do that in some other countries where the firstborn son gets everything. There are some countries in Europe, like Germany and Italy, where you cannot disinherit someone. So, if your kid has a drug problem and is in prison, you can't disinherit them. So in the United States, guess what? It's your stuff. You can say what you want done with it, okay? And the important part, though, is make sure that it's in writing, it's done properly, it's signed properly. Some of these documents need to be witnessed when you sign them. Some of them need to be notarized instead of witnessed. Make sure it's done right. Then keep a copy in a safe place, but not your safe deposit box, because guess what? if your safe deposit box contains the documents that give somebody authority to get into your safe deposit box, they can't get into it, okay? So either put whoever your successor trustee on your safe deposit box, or don't keep that document in your safe deposit box, because they'll need it to get in to the safe deposit box, okay? And make sure you have your accounts at any property of value in the name of the trustee of the trust. Make sure it's properly vested, or you're going to have a problem with it, or your heirs are going to have a problem with it. And the other thing is, confirm your beneficiaries on your accounts that are paid on death. So, for instance, a life insurance policy pays out on death. It doesn't go through your trust. You can't will it to somebody. It goes to whoever's named. It's a contract that goes to whoever's named as your beneficiary. The same with a retirement account, an IRA, a 401k. It goes to whoever's named as your beneficiary. It does not go through your trust unless you name it, the trust, as the beneficiary. Is it a good idea to name the trust as a beneficiary on a 401k? Probably not. Why? Because the trust tax rate, income tax rate, is 50%. And you have to distribute it out of the trust in the year of death, wholly. If you instead name, say, your kids can draw that over 5 years, and probably their tax rate is not 50%, unless they're Bill Gates. Then it might be. But there's a big difference. Now, should you sometimes name your trust? Yeah, sometimes. Say your beneficiaries are under the age of 18. Maybe you should name the trust, the trustee of the trust, not the trust. So trust itself doesn't have a personality in the law, so you have to name the trustee of the trust. So you want to make sure that whoever you have as your beneficiary is the right person as your beneficiary. Some people have gotten divorced and they never took care of taking the X off as the beneficiary. Some people, their spouse has died and they don't have an alternate beneficiary, and then when they die, what happens to that? Has to be probated because there's nobody named, right? So is it important to do all this stuff? Yes. Is it fun to do all this stuff? No. But you know what? It'll be really not fun unless you can talk to your kids with a Ouija board after you go. It'll be really not fun for your kids if you don't get taken care of. Again, the best gift you can give your family is making sure that all this paperwork is done properly so that they don't have to fight about it, they don't have to wonder about it, they don't have to go through court about it. They can just have it, if they're going to be grieving anyway, they can have it handled in a manner that's smooth and not upsetting any more than they're already going to be upset because they lost you. Okay, so as I say, it's a very important gift to give your family. So when it's time to go, there's the pearly gates. You won't need your pavement, and you can walk on through and go home. Thank you very much.
Is there any questions? We have a little bit of time.
Questions? Yes.
So that scenario of the trust being split, my mother has that case because my dad died in 2005. There's a bypass trust.
Yes.
And I tried to work with my mother to get, she's 82 and she's been living in a house since 75 in San Francisco, so it's worth a lot. And we were hoping to get a equity line of credit just as a safety net if she needs cash. But the bank won't let her take the equity because that's...
She doesn't actually own it anymore because it's in the bypass trust, right?
So is it possible to make it irrevocable again?
Okay, so irrevocable means you can't revoke it. Revocable means you can, okay?
Right.
So with a bypass trust, there's two different ways, actually there's three, One's really complicated, so I won't even go into that. But there's generally two different ways. One is you can change it if all of the beneficiaries agree and sign that they agree. Alternatively, you can go to court and give the court some good reason that it needs to be changed. And if you can convince the judge, then you can get it changed that way. The other problem with putting your personal residence in a bypass trust that you don't own anymore, you only own the right to the income, you don't get that advantage of the $250,000 tax-free capital gains because you have to both live in the property and own it for 2 of the last 5 years before you sell it in order to get that $250,000 tax-free capital gain. If you have put your house into a bypass trust, you no longer own it. And so you're not eligible for that capital gains tax break.
I believe her CPA at the time said that it was a tax advantage to do that, 2005 when that passed.
Well, so in 2005, the estate tax exemption limit was about $5 million, as I recall. So it may have been at the time, but now it's an issue. So come see me. There's a way to fix it. Okay?
And a quick question, I have a trust for my kids too, which I did about 3 years ago. And to update, what's the process of updating?
Can you repeat the question?
So what's the process to update your trust was the question. That's a very good question. So what I do is I give you the same questionnaire, and it asks you the same set of questions as if you were just setting up your trust from scratch. But then I want to see a copy of your trust because there may be things in there that need changing that you're not aware of just because you're not a trust attorney. I have a client whose trust was done by, I don't know, a friend of a friend, and it's the most complicated thing in the world. And it makes his son, who's not a U.S. citizen, his trustee, which means that then all of the income from the trust would be taxable to the son because if he's not a U.S. citizen, there's problems. I mean, the limit that you can pass is $65,000 instead of $11,450,000. Okay, so it's very complicated. But again, what you do is I give you that form, if you will. You scribble all over it. You give me a copy of your existing documents and what it is you want. And we sit down and we talk that through, and then I will prepare the documentation for you. If it's, sometimes it just makes sense to rewrite the whole thing and throw out the old one. And in that case, then we have to name it something different. And so we have to do another deed, putting your house in the new trust. So we'd have to have a deed where you sign off on it as trustee of the old trust to grant it to the trustees of the new trust. But sometimes it's just an amendment. And if it's just an amendment, we can just do an amendment to the trust and we don't have to change the name. Okay? That's a very good question. Any other questions? Okay, well, thank you again, Jean. Thank you.